The instruction included language that an initial aggressor is not justified in using physical force to defend himself from the counterattack that he provoked. Poole proffered a similar self-defense instruction, which omitted the initial aggressor language. So he asked the judge, hey, just do the standard one. Let's not talk about this initial aggressor stuff in front of the jury. The trial court rejected Poole's self-defense instruction because it found the state had introduced sufficient evidence warranting the inclusion of the initial aggressor language in the self-defense instruction. So both parties, the defense and the state, are entitled to any jury instruction for which there's an evidentiary foundation. So there's been facts presented to the jury that can support that jury instruction. The facts may be weak, they may be contradicted by other evidence, they may be inconclusive, they may be self-serving. But if there's more than zero evidence on an issue, and there's a jury instruction addressing that issue, the party is entitled to that jury instruction. That's true for the defense, and it's true for the state. So here the state had introduced evidence that Poole was the initial aggressor, if only from the testimony of the victims here. And that's enough to support the jury instruction. Now, whether or not the defendant was the initial aggressor is something for the jury to decide. But the state is entitled to this jury instruction. So that jury instruction read in relevant parts, quote, one of the issues as to counts 1 and 2, the use of force, is whether the use of force by the defendant, Poole, against Dante Long was lawful. On the issue of self-defense, you are instructed as follows. In this state, the use of force, including the use of deadly force to defend oneself, is lawful in certain situations if the required elements of self-defense have been met. However, and this emphasis is in the decision itself, folks, the bolding. However, an initial aggressor is not justified in using physical force to defend against the counterattack he provoked. In order for a person lawfully to use non-deadly force in self-defense, he must reasonably believe such force is necessary to defend himself from what he reasonably believes to be the eminent use of unlawful force, and can only use physical force to the extent he reasonably believes is necessary to defend himself. So we see in that one paragraph there, we see all the elements of self-defense, right? We see innocence. He's defending himself against, see if I can bold it here, against an unlawful force, right? He's not defending himself against lawful force, like lawful arrest by a police officer. He's facing unlawful force. He's the innocent victim of unlawful force. We see the element of imminence. The force he's defending himself against is an imminent force, an imminent threat, not a past threat, not a future threat, but one that's either actually occurring or immediately about to occur. We see proportionality. He can only use physical force to the extent that it's necessary. We don't see avoidance here, because avoidance is only applies in the stand your ground states. Missouri's not a stand your ground state. In the duty to retreat states, and Missouri's not a duty to retreat state. So avoidance won't be a relevant question here. In any case, if you're being threatened from a few feet away with a rifle, there is no safe path of retreat. And if the path of retreat is not safe, you're not required to increase your jeopardy in an effort to retreat. So even in a duty to retreat state, avoidance wouldn't be relevant here. And then we have the element of reasonableness. And just look how often reasonableness is mentioned here. In order for a person lawfully to use non-deadly force in self-defense, he must reasonably believe. First mention. This is all one sentence, right? First mention that such force is necessary to defend himself from what he reasonably believes. Second mention in the same sentence, to be the eminent use of unlawful force, and can only use physical forces to the extent that he reasonably believes is necessary to defend himself. 3 references to reasonableness in one sentence of the jury instruction. You think that reflects the weight and importance that use of force law places on that element of reasonableness? Absolutely. The standard jury instruction continues. The state has the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense, right? So the defense doesn't have to prove self-defense at trial. The state has to disprove self-defense beyond a reasonable doubt. Unless you find beyond a reasonable doubt that the defendant did not act in lawful self-defense, you must find the defendant not guilty. And then the more of the initial aggressor bonus instruction that the appellant objects to here. As used in this instruction, an initial aggressor is one who first attacks or threatens to attack another. You, however, should consider all the evidence in the case in determining whether the defendant acted in lawful self-defense. All right, so that's the quoted jury instruction with the initial aggressor bonus language. Continuing now with the decision. The jury found Poole guilty as charged. The trial court sentenced Poole as a persistent offender, so he's got prior convictions, to 20 years in prison on count 1, which I believe was the assault charge, 5 years on count 2, which I believe, I don't remember what the counts were. Let's go back and refresh our recollection. 20 years for count 1, which was first degree assault, 5 years in count 2, armed criminal action, and then more time for unlawful possession of a firearm, presumably because he's a felon in possession. Let's see. The 20-year and 5-year sentences were ordered to serve consecutively, which is somewhat unusual. And the 7-year sentence for the gun possession was ordered to run concurrently. In his motion for a new trial, Poole advanced the following grounds. 1, the trial court's admission of the high-speed chase evidence was inappropriate, reversible error. 2, the trial court's rejection of his preferred self-defense instruction, meaning the version of self-defense jury instruction without the initial aggressor, bonus language. And 3, the trial court's denial of its motions for judgment of acquittal. Oh, and there's a fourth one here. The jury's verdict was against the weight of the evidence, that no rational jury could have arrived at a finding of guilt here.